It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show.
Ay, tired of being Mr. Nice Guy to these fuck niggas. Got nothing to discuss with them unless it's about business. I replenish when they all diminish. Started caking, I ain't never finished. Can't kill him, I been too kind. When the money piled, I need y'all to witness. Pull up on them like calisthenics with the jewels on me. Met your chick, she amused for me. Sent music to amuse, I was not enthused when they put the blues on me. Wait, fuck that, time for me to bust back. Show me where the love at, ho. Niggas on the block with the gun strap. Homie finna dump that, hit him where his mustache go. Ayy, get on my level. When it come to bank, I pimp my teller. Never been a nigga that'll rock Margiela. Never come around, I bitch, y'all better. Might not never get to rock Coachella. I don't get no fucks, I think you want better. I'm about my cheddar, don't sprinkle no feather. I skate on track like Bam March. Every young nigga too hot, don't need no leather. I've been a living legend for a minute. I was at the Apache trying to sell a ticket. Nigga used to rap when Debo had the bitches. I've been learning about the boss and treat it like an auction. Labels gotta bid it. I ain't never been with Stallion. I can make a call and get the money printed. Bitch, I do not play when it come to this rapping. Studied the game when I lived in the attic. All of that struggle just made me a savage. Singing my praise on my edge, been jagged. Hating that nigga ain't fit in my jacket. I give you that shit, y'all nigga be tagging. Y'all bite my style straight trash. Y'all make it took 21 days, make stuff my habit. I'm gone.
What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this evening. Before we get started in this particular video, I want to go ahead and say, hey man, big thanks, big salute, big love to everybody subscribed to the channel. We have struck the 34,000 subscriber mark as of this morning. I greatly appreciate y'all. I do not take that shit for granted one bit. Even the haters, even the ones who be talking smack in the comments, I know y'all love to try to get a rise out your boy. It's all good, man. You can hate watch, you can bait watch, you could whatever the fuck you do. I appreciate you nonetheless. You know what I mean? When I really got into this, when I changed over to doing Inside the Industry, we're going on 2 years of this particular show. I didn't know where it was going to go. Didn't really have any expectations. So to be here at 34,000 and growing, it's amazing. So I appreciate y'all. Now, let's get into this Megan Thee Stallion Milagro update. The last time we spoke here on YouTube about this case, it was about who was going to be submitted for subpoena deposition, who was going to be called as a witness, right? And it was pretty interesting who Milagro tried to bring in as witnesses. I thought it was strange. She wanted Kelsey to have to come speak, which I don't know what her, whatever. She had Desiree Perez from Rock Nation on there. Looks like some of those names didn't go over all that well. We also know that Adin Ross is a part of the subpoena list. He's come forth with his legal representative. He's trying to get out of having to participate in a deposition. It's a lot going on here, and it's happening quickly. Now, remember, I believe trial for this case will begin in next year. So everything is moving swimmingly to go ahead and get this thing in motion. Let's go ahead and get to the docket, okay? So the first thing I noticed here the other day, we got a paperless order from the judge saying order for proceedings held before Magistrate Judge Lisette M. Reed, discovery hearing held on 9/15/2025. Daystar Peterson, as in Tory Lanez, declined through counsel Crystal Morgan to be deposed. All right, so he was scheduled to come in for a deposition. Of course, we know Tory Lanez is still in the joint, locked up, serving out his sentence. He was supposed to come in and answer for questioning. He declined to answer for questioning. His attorney, Crystal Morgan, said no. The total time in court was 45 minutes. And we'll see how things move from there. Okay? Now, following that, you got this order on motion for extension of time of discovery cutoff deadline. And this leads us to even more information. So it says here, this cause is before the court upon the notice of hearing ECF number 128, upon which the court held a discovery status conference hearing on September 5th via Zoom. At the hearing, defendant's counsel, and remember, defendant is Milagro Cooper, aka Milagro Grrrls. Her counsel made an ori tennis motion to extend third-party discovery and effect substitute service of deposition subpoenas to non-parties. Kelsey Harris, Megan Thee Stallion's former best friend, also has been cited in the proceedings in the litigation to have allegedly sent Milagro some sort of gift in the last couple of years. Alongside Desiree Perez, the CEO of Roc Nation, plaintiff objected to that request for failure to demonstrate good cause for deposing these non-parties and diligence in timely serving the subpoenas. Okay, and remember, of course, plaintiff is Megan Thee Stallion. Now, they get into local rules. They say our local rules are instructive here. Rule 26.1D states, completion of discovery, party and non-party depositions must be scheduled to occur, and written discovery requests and subpoenas seeking the production of documents must be served in sufficient time that the response is due on or before the discovery cutoff date. Failure by the party seeking discovery to comply with this paragraph obviates the need to respond or object to the discovery, appear at the deposition, or move for a protective order. Okay, Southern District, Florida, LR 261D, emphasis added. Rule 261H further states, reasonable notice of taking depositions, unless otherwise stipulated by all interested parties pursuant to Federal Rule of Civil Procedure 29 and accepting the circumstances governed by Federal Rule of Civil Procedure 30A, a party desiring to take the deposition within the state of Florida of any person upon oral examination shall give at least 7 days notice in writing to every other party to the action and to the deponent if the deposition is not of a party. And a party desiring to take the deposition in another state of any person upon oral examination shall give at least 14 days notice in writing to every other party to the action and the deponent if the deposition is not of a party. Furthermore, read together local rules 26.1D and H dictate that all discovery, including third-party discovery, must be diligently sought, so it may be completed by or before the discovery cutoff, or at least properly served within the deadline as to give the affected party or non-party sufficient notice. Here, the party stipulated to an extension of third-party discovery for 20 days, placing the deadline on August 28th, 2025. The parties agreed that no timing-based objections will be made within this 20-day period. At the court's September 5th hearing, defendant first moved to effect substitute service on the non-parties and further extend the deadline for third-party discovery. So as it pertains to Kelsey Harris and Desiree Perez, Milagro, she had already agreed that these dates were not to be moved and that she wouldn't do anything that would cause any extensions. Then she came with these requests for Kelsey and Desiree Perez to be subpoenaed for deposition, which then would have thrown them off schedule. Plaintiff lodged their timing-based objection during the hearing and in post-hearing submission to the court. Evidence proffered during the hearing and submitted to the court shows that defendant has not diligently sought discovery from these third parties within the already extended third-party discovery deadlines in a way that comports with Local Rule 26.1D and H. Namely, the evidence shows the earliest attempts to serve Ms. Perez being on August 19th, 2025 in Florida, 9 days before the deadline, and August 21st, 2025, 7 days before the deadline in New York. The earliest attempt to serve Ms. Harris was on August 20th, 2025, 8 days before the deadline in Texas. These attempts of service are not timely under the local rules. They even have footnotes here. While the first attempt to serve Ms. Perez in Florida would have been timely under the local rules for a deposition within the state of Florida, comments attached to the attempted service affidavit indicate that Ms. Perez does not actually reside in Florida, and so her deposition would not be taken here. Remember, you have to have it 14 days for non-parties out of the state. Further, as discussed below, defendant has known of the relevance of these witnesses for some time now and does not indicate why she is seeking such discovery this late into the litigation. Let's go back up. Defendant contends that she has shown good cause to seek the post-discovery cutoff depositions of these non-parties and exercise diligence in obtaining potentially relevant evidence from them during discovery. Defendant, however, fails to point to any information about the potential relevance of the testimony of these witnesses that was not apparent from the outset of discovery. Indeed, during the hearing and in post-hearing submissions to the court, defendant claimed that testimony from Ms. Perez and Ms. Harris is relevant to the underlying 2022 criminal case involving plaintiff and Daystar Peterson and as purported witnesses to the July 2020 shooting of plaintiff and its aftermath. Of course, Kelsey was there. This indicates that the defendant has known of these witnesses since 2020 and at the very least has known of their purported importance to this case since its inception in October 2024. This begs the question of why defendant was seeking discovery from them just days before the already extended discovery deadline, because you and your counsel are garbage, in my opinion. Further, defendant did not seek to substitute service until after the extended third-party discovery period had already ended when she raised the issue at the September 5th, 2025 hearing. Moreover, the court had set the hearing upon its own volition. See August 29th, paperless notice. In other words, defendant has known of the issues with serving the non-party since at least August 19th, 2025, yet failed to raise them over until 2 weeks later when the court itself set a hearing for September 5th. Thus, defendant does not demonstrate diligent effort to seek discovery given the deadlines, nor good cause for the court to extend the deadline to effectuate substitute service. Sounds to me that you're not going to get these two. They go into case law as to why this is relevant. Refusing to extend fact discovery when the party chose to propound discovery request too late to meet the discovery deadline. Sounds about right. Here, Florida, May 23rd, 2023, denying motion to amend answer in light of new discovery where defendant did not meaningfully seek the discovery at issue until the eve of the expiration of the 6-time extended discovery deadline. So procrastination seems to lead to, denial. Defendant's request is even more troubling in light of trial fast approaching in November. Oof. And the undersigned's previous warning to the parties on the importance of adhering to case deadlines. Damn, trial is approaching in November. That's sooner than I thought. The 11th Circuit has determined that a court does not abuse its discretion by denying a motion for extension of the discovery period where the parties had ample time and opportunity to conduct discovery yet failed to diligently do so. You've been twiddling your thumbs, tweeting away, being all up in everybody else's business without handling your own. Therefore, it is ordered and adjudged that defendant Milagro Cooper's request for substitute service of post-discovery deadline third-party deposition subpoenas is denied. Done and ordered this 15th day of September 2025 from the judge herself. So there will be no deposition for Ms. Desiree Perez or Ms. Kelsey Harris. So then the next thing that I noticed in the docket as of yesterday is Adin Ross. Adin Ross has filed his presence via his legal counsel, and he has filed a non-party motion to quash or protective order. Okay, remember, he has been hit with a deposition deposition request subpoena for Megan Thee Stallion. Non-party Adin Ross, by and through undersigned counsel, respectfully moves this court pursuant to Federal Rule of Civil Procedure 26C1 and 45D3 to quash or issue a protective order for a subpoena ducis tecum sought by plaintiff Megan Pete, and in support thereof states as follows. On August 28, 2025, plaintiff purported to serve a subpoena ducis tecum upon Mr. Ross, commanding both the production of documents and his personal appearance for deposition for September 16th, 2025. Instead of knocking on the door or ringing the bell, plaintiff hired a mariachi band to play music outside his home to lure Ross and serve him. This was too clever by half, or should we say, pararse de listo. I ain't gonna lie, I thought this was bullshit. When they came out and said that a mariachi band was playing outside of wherever Adin Ross was at, lured him outside and served his ass like some movie shit, I was like, man, ain't no fucking way. Nope. They literally say in the paperwork, in the legal document filed to the judge, they are confirming, in fact, that Megan Thee Stallion sent a mariachi band. I wonder if my motherfucking brother was with them, because my little brother played mariachi music out there in Texas. Anyway, personal service was not made. Mr. Ross has security who does not reside with him to shoo the band away. The security officer was not authorized to accept service. The mariachi band stunt trivialized the judicial process and was meant to harass and embarrass. Also, the subpoena seeks extensive documents and communications, including call logs, messages, payments, and social media posts to a person that has nothing to do with the facts of this case. The subpoena should be quashed or protective order issued for multiple reasons, including improper service, lack of relevance, undue burden, and harassment. So he is trying to argue that, one, they feel that the subpoena was served incorrectly and making a joke of the judicial system. And they also do not believe that they should have to submit call logs, messages, payments, and social media posts regarding Tory Lanez, I would assume, because they feel it has no relevance to the case. They then get into a memorandum of law issuing legal standard. They say the trial court is given wide discretion in setting the limits of discovery, and its judgment will be overturned only when a clearly erroneous principle of law is applied or no evidence rationally supports the decision. But y'all be coming out here talking like y'all got so much info from Tory and y'all been given the green light to talk shit. So yeah, instead of going on your stream and saying what you think you know, why don't you come to an official deposition and tell us what you think you know? I don't think that's irrational, but we'll continue. Federal Rule of Civil Procedure Rule 26C1 allows any person from whom discovery is sought to move for a protective order, which may be granted for good cause. Okay, Rule 26C gives the district court discretionary power to fashion a protective order. Under the good cause standard, the court must balance the competing interests of the parties and has broad discretion in determining whether a protective order is warranted. Rule 26 protects those from whom discovery is sought from annoyance, embarrassment, oppression, or undue burden or expense. Good cause exists to prevent plaintiff from taking the deposition of Rule 45D3 in turn states that on timely motion, the court must quash or modify a subpoena that requires disclosure of privilege or other protected matter. Under Federal Rule 45, a subpoena must be personally delivered to a non-party. Substitute service of process is not permitted. Okay? Meaning that the guard was not a good enough person to serve to give the subpoena to Adin. They say B, the subpoena must be quashed due to improper service. Whether personal service under Rule 45 is required or service at all remains flux. Rule 45 states that serving a subpoena requires delivering a copy to the named person. Thus, courts have found that service under Rule 45B1 must be personal to the named individual. Okay? You can read all of that. That's basically the point. When Florida in this instance is governed by Fifth Circuit precedent, the rule requires personal service of the target of the subpoena. Because a non-party has nothing directly to do with the case, a higher standard of service is required. Wright and Miller state that the longstanding interpretation of Rule 45 has been that personal service of subpoena is required. Non-party Adin Ross was not lured or served by the mariachi band tasked with delivering the subpoena because he was not personally served. The service was insufficient and its effect must be quashed. The subpoena is overbroad and is a fishing expedition. That is their description of it. Federal Rule of Civil Procedure 45D3A4 requires the court to quash a subpoena that subjects a person to undue burden. Additionally, Rule 45D3A3 mandates quashing a subpoena that requires disclosure of privileged or other protected matter if no exception or waiver applies. Well, Milagro is being sued for colluding with Tory Lanez when there is a protective order, an order of protection on Tory Lanez. So if he is indeed using Milagro to do his bidding, to do his messaging, to do his harassing of Megan Thee Stallion, bringing you into the fold as another example of somebody along with the DJ that don't spin, I do think that that is relevant because there are other sirens in media that have been doing the bidding of Tory Lanez. That's just my personal opinion. We'll continue to read. So he doesn't want his text, cash transactions, and all those other things to be revealed, or he wants to have a protective order applied to those things. Courts have consistently held that relevance is a prerequisite for non-party discovery, and the burden of demonstrating relevance rests with the party seeking discovery. Federal courts recognize that non-parties deserve heightened protection from discovery burdens because they have no stake in the litigation. As the advisory committee notes to Rule 45 explained, the rule is intended to provide adequate protection for persons who are required to assist the court by giving testimony or producing documents. The 11th Circuit has emphasized that non-party discovery should be limited to information that is clearly relevant and necessary to the litigation. Under Federal Rule of Civil Procedure 26B1, discovery is limited to matters that are relevant to any party's claim or defense. This relevance requirement applies with even greater force to non-party discovery. Courts have quashed subpoenas directed at non-parties when the requesting party cannot demonstrate how the non-party possesses relevant information. Yeah, this is a whole bunch of bullshit, my brother. This complaint in this action makes no mention of Mr. Ross whatsoever. A review of the pleadings reveals that the dispute between Ms. Pete and Ms. Cooper does not involve any facts, circumstances, or legal theories that would implicate Mr. Ross or suggest he possesses relevant information. The complete absence of any reference to Mr. Ross in the complaint is strong evidence that his deposition would not yield discoverable information. Not sure that's how that works, but I wouldn't know because I'm not a legal professional. The party seeking Mr. Ross's deposition bears the burden of demonstrating relevance. Federal Rule 26B1 limits discovery to information relevant to any party's claim or defense. Nothing in the operative complaint nor the subpoena itself offers any explanation what information Mr. Ross possesses relevant to the claims asserted by Plaintiff Pete, the defenses raised by Defendant Cooper, the damages sought in this litigation, or any other matter germane to this case. Without such a showing, the subpoena constitutes an impermissible fishing expedition that courts routinely reject. The trial court, however, is given wide discretion in setting the limits of discovery. As a non-party to this litigation, Mr. Ross is entitled to enhanced protection from discovery burdens. Unlike parties who chose to engage in litigation, non-parties have not voluntarily subjected themselves to the discovery process. This court should apply a higher level of scrutiny to this non-party subpoena and require a stronger showing of relevance and necessity. The subpoena should be narrowly tailored and limited to information that is necessary and is reasonably calculated to lead discoverable evidence. In this here, the complete absence of any connection between Mr. Ross and the subject matter of the litigation demonstrates that his deposition would impose an undue burden without any corresponding benefit to the administration of justice. In conclusion, they say the court should grant the motion to quash, do away with, or grant a protective order to non-party, Adin Ross. So that's the request from Adin Ross's legal aid to basically be set scot-free from the subpoena, or there should be a protective order on any information that he submits. Well, the judge didn't even think you were worth a paper filing. The judge says here in the docket, paperless order striking 147 notice filed by Adin David Ross. 146 motion to quash, motion for protective confidentiality ordered, filed by Adin David Ross. Parties are to comply with Judge Reed's discovery procedures found on the court's website entitled Standing Discovery Order for Magistrate Judge Lisette M. Reed. See also ECF number 62 at 3. Specifically, the party requesting relief must properly confer or attempt to confer with the opposing party, i.e. in person or over the phone regarding the relief sought. If parties are unable to resolve the dispute, they must request a discovery hearing by contacting Judge Reed's chambers by email, in which they shall copy all opposing counsel, certify a proper conferral or attempt occurred, and provide all counsel's availability for a hearing. Please see the standard discovery order for more details. Motions terminated. Okay? So the judge says, get the fuck out my face. Leave me. It is your responsibility and your legal team's responsibility to reach out to Megan Thee Stallion and her legal aid to try to come to some understanding. Y'all must confer with each other. You have to run this by the person requesting you first before you come to me. You have tried to you have tried to circumvent, is the word I'm looking for, the actual process, and you wanted to come straight to me. You came straight to me. You got your shit mutumboed. So, as it stands, Adin Ross will have to move forward with deposition unless he confers with Megan Thee Stallion and they come to some sort of resolve, whether that be, because I don't think they're going to let him off the hook because they've requested your presence. So maybe they may acquiesce to the request for protective order on whatever information he submits. If he complies and submits information regarding Milagro or Tory Lanez, or they may say no. And then they're going to have to set up a hearing in front of the judge to go over the specifics of what will be admissible, what's not, or if he'll have to appear at all. But Adin Ross and his legal team tried to go around the situation rather than go through the proper process. So that is the latest update regarding Megan Thee Stallion and Milagro Grrrls as far as their witness list, their subpoenas, and their, witnesses that they are trying to bring to the front. Adin Ross is trying to evade, and it looks like Kelsey and Desiree Perez will not have to come in for questioning because, once again, Milagro did not go through the proper process either. Okay? So everybody seems to be handling this situation all the way wrong, from their personal involvement, their social media involvement, and even in their legal involvement. Everybody, except Megan Thee Stallion and her side, seem to be having the game fucked up. But let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, Become an Insider. I'm going to catch y'all on the next one, man. Peace.
Ain't no way to stop it when a nigga poppin'. Pull up, start a problem, I got plenty options. Homies from the project, we the trending topic. I got bennies in my wallet, fuck your money. All I could get, flooded the knowledge, I flooded my wrist. Tell me I rap for the glamour and glitz. Got on my shit, now they ran me on list. Filling my pocket, I'm taking a trip. Call me a genie, I'm filling my wish. When it come down to me and get in my bag, I gotta get it, I pay for the lift. I got a baby, we coming legit. Roll with the big dogs. I need my cut like fit now. Buddy got shot like Sim car. Married to the game like in-law. Do what I please, move with the breeze, right to believe. Shawty, she love me, she coming to tease. Ready the haters, we cutting the weeds. Give me my space, oh man. Got me a taste, oh man. Flooded the face, I'm running a race, I cover the bases, all down. Nigga, don't try me, I'm on my square. Cardiac diamonds, I want me a pill. Treat all this money like I got a meal. Everything closer than it might appear, yo. Bitch, I got my mask on now, I don't want your germs here. I've been getting paid since the first time on my third tip. Popping on the net, fuck a local, I got turf here. Fucking with the squad, we gon' put you on some merch, yeah.